Thank you very much, Mr. President. Excellencies and distinguished participants, I'm very glad to join today's discussion on this important and timely issue. A UN Tax Framework Convention would address issues including the digital economy, abuse of transfer pricing rules, tax evasion, and a wealth tax on high net worth individuals. This could raise sufficient revenues for developing countries and significantly support the right to development, as we heard, and the Sustainable Development Goal 17.1. However, unfortunately, current trade and investment treaty negotiations could undermine the effectiveness of such a UN tax convention. For example, on the digital economy, at the World Trade Organization, the current multilateral moratorium on imposing customs duties on downloading electronic transmissions, such as movies from Netflix or songs from Spotify, is scheduled to expire by March 2026 at the latest. This moratorium has been calculated by a UN economist to have cost in 2020 alone Thailand $3.6 billion in revenue, Mexico $2.6 billion, India $1.5 billion, and so on. However, 91 WTO members have chosen to negotiate a plurilateral, or JSI, e-commerce agreement, where the latest text, which has been described as stabilised by the co-conveners, Australia, Japan and Singapore, includes a permanent and enforceable ban on customs duties on these electronic transmissions, and this is portrayed as having been agreed to, despite the objections of 20 of the participants to this text. These kinds of permanent and enforceable bans on customs duties on downloads are also proposed in some free trade agreements, for example, the EU's proposal to Indonesia. We also heard today about the importance of digital services taxes from South Centre, but the US is currently suing Canada under the US-Mexico-Canada agreement, claiming that Canada's digital services tax on revenue from online marketplaces, advertising and social media platforms violates the national treatment provisions in the services and investment chapters of that free trade agreement. The second way that trade and investment treaty provisions can undermine the effectiveness of any UN tax convention is if it attempts to prevent abuse of transfer pricing rules. We heard today the importance of addressing this, and some governments have tried. For example, the Andean community did not allow royalties between related firms, and I understand India capped royalty payments until 2009. When that cap was removed in India, its royalty payments to overseas parent companies increased by 5 times, reaching up to 33% of its FDI inflows. However, if a government wanted to limit abuse of transfer pricing by capping voluntary license royalties, this can be restricted by disciplines on performance requirements in bilateral investment treaties or free trade agreement investment chapters. For example, the EU has proposed this in its free trade agreement negotiations with India, a ban on capping these royalties, except in the sectors that the EU agrees to exempt. A third way that these trade and investment treaty provisions can undermine the effectiveness of a UN tax convention is if it attempts to prevent tax evasion, which we heard was very important to do. To give you 2 examples, governments such as New Zealand require tax records, which are stored on the cloud, to be stored on a server in New Zealand, so that they can easily check for tax evasion without having to resort to some mutual legal assistance treaty to try and get the information stored offshore, because this can be slow, expensive, and ultimately unsuccessful in the experience of many countries. However, there are cross-border data flow proposals in some free trade agreements, for example, the EU's proposal to Indonesia, and these may come back in the JSI e-commerce future negotiations, which can prevent requirements to store data locally. And the proposed tax exception includes a requirement copied from the World Trade Organization that governments have failed to satisfy 86% of the time. Another way that tax evasion addressing tax evasion can be undermined by these trade and investment treaties is that some governments, such as the USA, check the source code in software that is used in tax return preparation, compliance, and planning to make sure that tax return claims are correct. However, the source code provision that is proposed in some free trade agreements and which may return in the JSI commerce can prevent this as well. Fourthly, and more generally, of course, we know that foreign investors have used investor-to-state dispute settlement in bilateral investment treaties and free trade agreements to challenge taxes, whether they're capital gains taxes, increase in windfall profit taxes, and royalties. There have been 165 known cases challenging tax measures as of 2021. This is 15% of the known ISDS cases, brought against 47 countries, and more than 90% of these cases were brought by investors from developed countries. For example, India calculated that a foreign investor owed it $6 billion in taxes. The foreign investor did not want to pay this, so they sued India via ISDS. India lost and had to pay the foreign investor $1.2 billion US. Some countries, such as those in the EU, are still proposing ISDS in their free trade agreements, for example with Indonesia, despite the EU itself withdrawing from the Energy Charter Treaty because it was worried that its ISDS restricts the EU's ability to take climate change measures. Of course, there are many other provisions in trade agreements that can cause revenue losses with flow-on impacts for the right to development. For example, free trade agreements usually require the removal of most tariffs on imports, and those joining the World Trade Organization after 1995 are usually required to widely lower their tariffs. So recently we saw Timor-Leste, a least developed country, was required to bind 100% of its tariffs at an average of 11% in its WTO accession, even though Myanmar, also a least developed country in ASEAN, which did not have to go through this accession process, only had to bind 19% of its tariffs at an average of 83%. Developed countries also often require, in their free trade agreements, the removal of tariffs on exports of raw materials, which many developing countries have been using to raise revenue and encourage value-added processing. And the WTO's optional plurilateral agreements, which have been concluded on investment facilitation and services domestic regulation disciplines, also restrict the ability to use licensing fees to raise revenue at all levels of government. These licensing fees are often used by governments to pay for public health programs and clinics, rubbish collection and other public services. So although a UN tax convention could be an important enabler for the right to development, it is unfortunately being undermined already by provisions being negotiated and agreed in trade and investment agreements, which are enforceable via ISDS and states suing each other at an international tribunal, with the winning country being able to raise the tariffs on the losing country until it changes its tax laws and so on to comply. I thank you.